Void judgment.
To our Constitution and unacknowledged by our laws, it can only be
Sovereignty and living.
talking about the Pope's canon law, which is Roman law, which is also why millions of people are fleeing Europe at that time because of the Pope's tyranny there. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed at the preservation of the properties of the people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put into any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and 201. With the Spanish Inquisition and other oppressions, the use of information has a long history. For example, has a long history. For example, Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the crown. Okay, that's the Vatican's crown.
And that's what they're using to convict us. I've done a couple other videos. They are charging you with information, not by affidavit under penalty of perjury from the victim.
Okay, blacks.
And therefore, they can never, ever get subject matter jurisdiction, in-rem jurisdiction, and personal jurisdiction. And what would that be? The nature, and the cause. And the cause.
Book 4, Blackstone's Commentaries, page 310. Courts ecclesiastical. Spiritual courts. Those courts are held by the king's authority as supreme governor of the church for matters which chiefly concern religion. And that's Book 4 of the Institutes, that's Coke. And the laws of the Constitution, whereby the Church of England, the governed, are 1, diverse immemorial customs, 2, our own provincial constitutions, and the canons made in convocations, especially those in the year 1603, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. And that same stuff is going on today. That's what they're doing with Donald Trump. That's what they're doing with all sorts of people that we're dealing with. Trying to help them get it resolved. Trying to help them get it dismissed. The Pope's canon law, which is Roman law, Sestake Usufruct, was brought into America first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish.
And that's actually the merchant uses the same thing.
The law of nature from international law. And then with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestake Use. That's at 1431, Stat 1432. The Pope's minor estate, Sestake Usufruct, is now codified at 31 CFR 363.6 and are unconstitutional because municipal law was the law of the dependent papal ecclesiastical city-states. civil or municipal laws that which every sovereign kingdom or state has appropriated for itself. The appellation of municipal was originally confined to the laws of the municipia or dependent states. And that's Encyclopedia Britannica, or a Dictionary of Arts and Sciences, 1771, Volume 2, page 883. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy, and on the northwest and Naples on the southeast area, 17,822 square miles, population in 1833, 2.742 million, capital Rome, population 153,000, government an elective monarchy, the Pope for the time being the absolute sovereign, with a consulting assembly of cardinals. Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome, the capital of the Pope's territories and of Italy, and anciently the millrace of the Roman Empire. It was also called canon law. The civil or Roman and canon law, though they're not perhaps to be deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground than that they were conformable to the civil or canon laws, and a special, so civil and canon laws. The civil laws is the canon laws. And the special statute was judged necessary. Anyways, I could read all that stuff if you want to go back and read it. I'll upload the file. The Pope's ecclesiastical city-states are now called the Vatican, and it continues to this day. This is the Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the parts of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. Unconstitutional because of Article 1. Article 1, an amendment. Congress shall make no law respecting an establishment of religion, and the Pope's necromancy, sesticate v usufruct, which is now called a minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor, and that's 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in the Treasury direct account. It goes on and talk about that. The Pope's sesticate v usufruct minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy and satanic. I think I could probably... There we go. This is Deuteronomy 18:10-12. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, or that useth divination, or an observer of times, or enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. Which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17.
And moreover, it is in the book that God, does not respect the person. And he put that in there 16 times.
To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as made by session of particular states and acceptance of Congress become the seat of government. To deceptively assault people with a quasi-contract. I'm just looking on YouTube. I don't see any questions. A subset in its origin and action of tort, a subset was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of the distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts.
This brilliant device keeps your home cool in summer, even during heat waves and...
Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contracted in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it. Which requires the Pope's fiction of law, minor estate, U.S. citizen. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the District of Columbia expand to anywhere on the planet with their plenary power. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for the Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And because plenary power is a dictatorship under the Pope's canon law, which is Roman law, plenary jurisdiction of courts full and absolute power of the subject matter and the parties of the case. Plenary is full, complete, entire. Plenary, full, complete, the courts of admiralty and the English ecclesiastical courts, causes or suits in respect of different courses of proceeding, and each are termed plenary or summary. Plenary power is a plenary authority. It's a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus, and plenary power, complete power over a particular area with no limitations. The term is often used to describe the commerce power of Congress under the Commerce Clause, Article 1, Section 8, Clause 3. Congress is granted full power over interstate commerce. The course has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. Fake Judge Hal R. Ray and Fake Judge Reed O'Connor are operating as bought and paid for administrative clerks, masquerading as judges under the Pope's canon law, Roman law, in bad behavior, which is a non-judicial proceeding, because whenever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and subsequent amendments to the present day, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Which means they were legislators engaging in legislative acts against me, a named individual, which is a bill of attainder or a bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment which says Congress shall make no law respecting an establishment or religion, because it's from the Pope's Roman law, also known as canon law, because they have imposed martial law rule, which is why we took up arms in 1775. And this is that cause of necessities for taking up arms, 1775. I'm not going to read it again. With the bankruptcy emergency, it's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent, HJR 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. And that's U.S. Congressional Record, March 17, 1993. Since March 9, 1933, notice the same date, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything's changed? Absolutely not. Martial law rule is the law of emergency and necessity. This is Ex parte Milligan, U.S. Supreme Court. There's three kinds of martial law. There's full martial law when actually invaded by a foreign enemy or insurrection. Troops are put on the streets. You see some of that happening right now in Los Angeles. Martial law proper is the law of the armed forces when a sergeant tells a private what to do, enforced by court-martial. Martial law rule is the law of emergency and necessity. It's used during peace times. It can go on indefinitely. The Pope's bar members on the bench will tell you, I can do anything I want. And this is a non-ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court in the case Diet versus Turner. This is a war over the intrusion of civil law and the common law. The court in Diamond v. Harris calls the civil law, which is statutory law, superior equity. And then the quote in the Diamond v. Harris, it's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt the civil law, even though it had the merit of superior equity. And it goes on. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. That's why they can say, I can do anything I want in this court. Because common law is taken from the Holy Bible, and under martial law rule, equity does not follow the common law. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter, the Bible. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guides by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Which makes it satanic. And the Pope's private bar guild Satanists are using the Pope's canon law, which is Roman law of capitis diminutio. Capitis diminutio is the maximum loss of status through the use of capitalization. highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave.
You know how amazing this razor is?
To populate the prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. And because
Yeah, thank you, Ronald Reagan.
the administrative proceedings under the Pope's canon law, which is Roman law, there are more people in prison in America as a percentage of the population than there are in communist China or the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the Pope's private bar guild Satanists doing it would get their necks stretched. If a man be found stealing any of his brethren or the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. Deuteronomy 24:7. And the Innocence Project estimates that 60% of prisoners are innocent, but it's such good business for the Vatican and their canon Roman law so-called courts, which is one of the grievances in the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. Well, how do you destroy lives of our people except by putting them in jail? All of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. The Pope, the Vatican, now owns and operates the bankrupt 1871 corporation at 16 Stat 419, as evidenced by the Roman Achaea military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia,